From the PEP Radio Newsroom, this is the Hourly News Blast. HuffPost is reporting conservative Supreme Court justices on Tuesday appeared sympathetic to arguments that states can ban transgender athletes from playing on girls' and women's sports teams. The justices heard more than 3 hours of arguments by Idaho and West Virginia, as well as a Trump administration lawyer defending laws that bar transgender athletes. The two cases heard back-to-back on Tuesday, Little v. Hecox and West Virginia v. B.P.J., were first brought by a transgender college student and a high school student, respectively, who alleged that these laws violated their rights to equal protection under the Constitution and federal anti-discrimination law. But the Supreme Court's 6-3 conservative majority seemed poised in both cases to accept the state's arguments that transgender identity does not equal sex, and therefore the Equal Protection Clause of the 14th Amendment doesn't apply. During the first case to be heard in the back-to-back session, Little v. Hecox, both conservative and liberal justices raised questions, including those about what level of scrutiny to apply to anti-trans sports bans and whether this case was itself valid. But it was during the second case, West Virginia v. B.P.J., that the conservative justices seemed to lean toward allowing state-level bans to stand, focusing on how to square transgender status and sex in terms of anti-discrimination law. This case comes from Becky Pepper Jackson, now 15, who sued the state 3 years ago when she was barred from trying out for the girls' track team, despite having received medication that stopped her from ever experiencing male puberty. Pepper Jackson's family argued, and the lower courts agreed, that the state's law violated her rights to equal protection and Title IX. Justices waded through a variety of hypothetical questions about differences between boys and girls with respect to everything from calculus to chess. But Justice Amy Coney Barrett seemed eager to avoid getting into similarly situated arguments. I think it opens a huge can of worms that maybe we don't need to get in here, she said. However, other conservative justices pressed lawyers on broader questions of the definition of sex. Hashim Mupan, arguing on behalf of the Trump administration for Idaho and West Virginia, said that it doesn't matter if an athlete's testosterone levels have been suppressed, as is the case with both Hecox and Pepper Jackson, because no amount of hormonal therapy can change their sex, as West Virginia defines it. Under West Virginia's statute, biological sex is solely based on a person's reproductive biology and genetics at birth. Joshua Block, an attorney for the American Civil Liberties Union representing Pepper Jackson, said that Title IX, which Congress passed in 1972, bars discrimination on the basis of sex and did so without defining it. He urged the court not to make a decision in this case based on West Virginia's definition of sex. I think the purpose of Title IX is to make sure sex isn't used to discriminate by denying opportunities, Block said. Our argument is that there's a group of people assigned male at birth for whom being placed on the boys' team is harmful, and there's a word for those people: transgender girls. Block said he would accept some kind of loss at the Supreme Court that might still allow the case to continue in lower courts, which have largely ruled in favor of the transgender plaintiffs. Lawyers for plaintiffs in the first case of the morning similarly hoped for a remand decision by the justices. At the center of the case is Lindsay Hecox, a senior at Boise State University, who sued over Idaho's 2020 law banning transgender girls and women from playing women's sports. She argued that the law violated her rights to equal protection under the Constitution, and she eventually won her case in the lower courts. In September 2025, Hecox argued that her case is moot because she no longer plays or intends to play any college or team sports in the state. Justices Sonia Sotomayor and Ketanji Brown Jackson pressed on that line of thought and highlighted the negative attention the plaintiff has received for being part of the lawsuit. If the justices don't choose to dismiss the case as moot, they argued, they would be forcing an unwilling plaintiff to continue to be part of a high-profile lawsuit. Such a decision could be a dodge for the court. If the justices decide the case is moot, there would be no reason for them to rule on it, and the case would likely go back to the lower courts for any further legal process. These cases could have broad implications, not only on the fate of other bands across the country, but also raise other legal questions around privacy, sex discrimination, and how transgender people are treated more broadly under the law, advocates told HuffPost. The Trump administration has targeted transgender people since his return to office last year by threatening to withhold federal funding from schools with trans-inclusive athletic policies, ousting trans people from the military, and barring trans people from updating their passports with the correct gender marker. That's the news blast for this hour. PEP Radio is available on the Live 365 app, the PEP Radio page at paequality.com, Roku, and Alexa. Up next, we have the Meadville area weather forecast here on PEP Radio.